I want to say a special welcome to those who are watching us via our live stream, made possible by a grant from the State Justice Institute. We're very thankful for that. Those of you who were with us yesterday in both plenary and breakout sessions heard both implicit and explicit reference to Ferguson, Missouri, the DOJ report, the operation of the courts there, the need for improvement. We're so happy and lucky this morning to have with us, to speak to us, people from Missouri. I'm going to turn this over to Judge Gary Lynch, an appellate court judge from Missouri, who will introduce the rest of the panel and to get us started. Judge Lynch.
Thank you. Good morning. My other panelists I'm pleased to introduce I'll start with Patricia Breckenridge. She's been a trial judge for 13 years in Vernon County, Missouri, spent 15 years as a judge on the Missouri Court of Appeals. The last 9 years has served on our Supreme Court and is currently serving as the Chief Justice of our Supreme Court in Missouri. The next panelist is David DeWhite. And David just received last year his Bachelor of Science degree in Biomedical Engineering from Washington University in St. Louis. He is a Communications and Media Fellow with the Ferguson Commission last year, and this year is a Communications and Strategy Catalyst at Forward Through Ferguson, the group charged with implementation of the Ferguson Commission. And you're going to hear more about the Ferguson Commission in our presentation. And finally, the last panel member is Booker Shaw. Booker spent 19 years on the trial bench in St. Louis, spent 7 years on the Missouri Court of Appeals as a judge, retiring in 2009 to the life of ease as a partner with the Thompson Colburn Law Firm in St. Louis, Missouri. I'd like to set the stage just briefly for our presentation. In any crisis, leaders emerge, but often they come from varying backgrounds and perspectives, having different agendas, and may have very different opinions about the causes of and the solutions for the problem. Often, unfortunately, some leaders are perceived as doing nothing but complaining, assigning blame, or being defensive, which leads to a lot of finger pointing. Finding solutions, however, takes a lot of hard work from those leaders to find ways to turn those pointing fingers into hands joined in finding a solution to the problem. That's the kind of hard work we are attempting to do in Missouri in response to the Ferguson crisis. I'd like to give you a brief historical lesson on Missouri municipal courts. Like many states, Missouri has a long 150-year history of autonomous limited jurisdiction courts. The magistrate courts, the juvenile courts, the probate courts, and of course the municipal courts. In 1976, however, the Missouri Constitution, the judicial article in the Missouri Constitution, was amended to provide for only 3 courts. The Supreme Court of Missouri, that had limited appellate jurisdiction and also assigned supervisory authority over the inferior courts. The Court of Appeals, which had general appellate jurisdiction and was also assigned supervisory authority for lower courts. And then the Circuit Court, which is the trial court. And that constitutional amendment took all of the limited jurisdiction courts and made them divisions of the circuit court. This worked well for most of the limited jurisdiction courts. The juvenile court became the juvenile division. The probate court became the probate division of the circuit court. However, we did not do a good job of integrating the municipal courts into as a division of the circuit courts. I think there's a lot of reasons for this, but primarily our Constitution retained the authority to municipalities to hire municipal judges and to provide municipal court facilities and staff for those judges. The municipalities also were given constitutionally the ability not to have a municipal judge, but to rather have their municipal cases heard by a state judge in a state court facility using state staff. That led to kind of a bifurcated system. Some municipal cases were heard in the municipal division of the circuit court, but by and large, most municipal divisions continued having their municipal judge, just as they had always done it, had the same municipal court facility, just as they had always done it, and the same court staff. So, quite honestly, the 1976 constitutional amendment had little practical effect on the operated municipal courts. And we know that because 40 years later, we now talk very freely about the juvenile division of the circuit court. We talk about the probate division of the circuit court, but we still refer to the municipal courts. While I was aware, this de facto municipal court autonomy seemed to work, just as it had for decades. The municipal judges in the municipal courts did their thing, and the state judges in the state courts did their thing. While I was aware of this seeming disconnect between the Constitution and how it was working on the ground from my perspective in the Ozark Hills of southwest Missouri, I heard few complaints about municipal courts. So I figured, if it ain't broke, don't fix it. Then in August of 2014, Ferguson burst into the national spotlight, and it very quickly became apparent that the de facto autonomous municipal courts were in some instances severely broken. I turn to David now and ask David, what was it like in the community of Ferguson and in the aftermath? What view of the municipal courts did the community have?
Thank you. So when Michael Brown was shot back in August 9th of 2014, I was just about to enter my senior year of college at Washington University in St. Louis. And with others at local schools in the region, was able to form a group that went to a lot of these protests, engaged with a lot of the community members. And I can't underscore enough how much there can be a lack of trust in the Black community of these courts. And so with all the unrest that happened following Ferguson, the governor sought to do something, to act, to find a way to move forward. And so the Ferguson Commission was born out of those tragic circumstances with the shooting death of Michael Brown. And that moment really bore a movement, regardless of what the individual facts of that case are. It really brought to the surface these deep and divisive issues that Black communities across the country have faced. And so these include issues with the courts and the police departments, as the courts we're about to talk about today, but also in educational systems, healthcare systems, in housing, transportation, all of these various structures that intersect with our lives every day and affect our opportunities and our livelihood. And ultimately, that moment with Michael Brown was predictable. It was predictable in a country that has vastly different health outcomes for Black people than it does for white people. In St. Louis, in North City, a mostly Black region, compared to a white suburb that is only a 15-minute drive, there's an 18-year difference in life expectancy. It was predictable in a municipality like Ferguson, where Black residents were 68% less likely to have their cases dismissed by a judge, where they were 50% more likely to have their cases lead to a warrant, and in a state where Black motorists were 75% more likely to be stopped for traffic stops. And so in this environment, we really can't, I just want to underscore, and we really can't confuse that when Black people are taking the streets, they're protesting, they're out here risking their livelihoods, their jobs, their personal safety, that they're fighting for their children, they're fighting for their human dignity, they're fighting for justice, they're fighting for a vision beyond the current state, a status quo that actively through our systems and practice and policies denies opportunities to entire classes of people and has real impact on their lives. So they're fighting for a more just world, and so I just really wanted to presence that with the events, especially of this past week, and protests that are even going on today. And so I just say all of that as well because we can't talk about the origins of the commission and the origins of the work that we're going to talk about today without presencing those in these protests that have swept countrywide and this discussion that's swept countrywide in the wake of Ferguson. And so the commission was tasked by Governor Nixon of Missouri with conducting a thorough, wide-ranging, unflinching study of these issues. So a group of 16 individuals spanning activists, educators, lawyers, police officials, and faith leaders were gathered together to study these issues. And it was the largest commission and resulting community process with calls to action and recommendations. It was the largest such process in the country that has happened after these the recent unrest. And so it was co-chaired by Reverend Starsky Wilson and Richard McClure, and led by Managing Director Bethany Johnston-Dravois. And in their words, the commission sought to be a bold experiment in inclusive democracy. It brought together 100 regional leaders, over 30,000 volunteer hours from residents and citizens, over 3,000 attendees across the 60 public meetings that occurred across the span of a year, and resulting in 189 policy recommendations for how the St. Louis region could move forward towards a more racially equitable and just region. A region that listens and centers youth voice, that thinks about generational systemic change, and really breaks out of our siloed thinking on how we can address these issues. So at the community's urging, one of the largest things that we heard from the community was that municipal courts and municipal governance were one of the chief things that they wanted to talk about following Ferguson. And so there was a municipal courts and governance working group as part of the commission that studied these issues for about 9 months. And so I just want to talk quickly on some of the findings that were brought to light, not only by what we traditionally think about as expert testimony from lawyers and other groups that work on these policy issues in the region, but also the experts in their personal experiences and in their lives of dealing with these municipal courts. And often we don't really presence and think about that kind of expertise, and we don't give it the credence that it deserves. So some of the realities that were brought to light is that issuing arrest warrants for nonviolent offenses was very common across the region in Ferguson, a city of about 21,000 people. Over 32,000 arrest warrants were issued in 2013 alone. And Ferguson wasn't even the worst of the courts in the St. Louis County. Similarly, Pine Lawn, that had a population of 3,000, issued 5,000 warrants, bringing the total outstanding warrants at that point to 23,000. And so it was very common to hear about people that would be in a police stop and find out in that moment that they had an arrest warrant from 10 years previously that was still haunting them to that day. We found that jailing nonviolent offenders can really destroy lives because they need to go to a court that only operates a few times a month, and at a certain time they might have to leave their job, and often low-paying jobs, and risk losing their license, not be able to care for their kids. We found that municipal courts in the region often compromise the constitutional rights of citizens. They found evidence of detaining of defendants for excessive periods of time without due process, holding defendants on their inability to pay the fines and fees, which were often exorbitant, and defendants entering guilty pleas without really knowing what their rights to counsel were. There are also conflicts of interest that were all too common with judges working as prosecutors and as judges in various municipalities, which really hurt the way that individuals saw their courts and felt that they would be correctly and justly adjudicated in these cases. They found that often these courts were inefficient and instructive. They had barriers to transparency, found that often records were closed or didn't exist or disappeared, that they were inefficient, costly. And then also we found that courts withheld critical information from defendants. that those who would receive municipal citations or summons to some of these courts really wouldn't be provided with the essential facts that they would know, critical to be able to work and find your way through these systems. We found that often they didn't know how much they knew, whether they had warrants out for their arrest, like I mentioned, many years later, didn't know how to pay the ticket, didn't know what their payment options were, didn't know if there were alternatives to fines and fees if they were indigent and didn't have the ability to pay for those fines and fees. And so out of that, issued a set of calls to action, and I'll just cover some of the signature ones, but you can definitely find them all at forwardthroughferguson.org. And so some of those were providing municipal court support services, thinking about municipal courts as centers of community justice, finding new ways to train clerks, municipal court judges, jail officials, as well as city government employees on their constitutional rights, eliminating incarceration for these minor offenses, collecting municipal court debts more like civil debts, so changing the way that we interact with those, consolidating municipal courts was recommended, creating a Bill of Rights for defendants so that they know going in what they can expect from a judge. And so those are just a few examples.
Do you recall, David, if on the Ferguson Commission there were judiciary representatives on the commission that heard and gave input from the judiciary's point of view?
I believe through, so the structure was that there were about 19 full commission meetings where the 16 commissioners would come together and talk about what had happened in the various working groups. And then there was the Municipal Courts and Governance Working Group that had about 10 meetings across the 9-month span. And so through that, they heard testimony from a lot of different professionals, both from the standpoint of activists as well as from those involved with the judiciary and lawyers that worked in these various municipalities as well.
Okay. Patty, did the Supreme Court have or develop a response to these things that came to light about municipal courts?
The Supreme Court was unaware, as Gary mentioned. I think the court system as a whole outside of St. Louis County was unaware of these issues until the month before Michael Brown was shot. We received a letter, a white paper from the Arch City Defenders, a group of activist attorneys who saw the problems in municipal courts and brought them to the court's attention in this letter. And they pointed out some of the problems that had been mentioned, but the letter concluded by saying, and we're working on solutions and we'll get back to you with solutions. And so the courts, at least my first indication of this was that letter. Within the next month, Michael Brown was shot, there was a civil unrest and media attention and a real shock and awareness of the problems mentioned. The court was caught in the historical perspective that the municipal courts had acted autonomously. We all recognized the Constitution said we were a uniform system, but we hadn't really functioned as one. And so we had increasing awareness, and then the DOJ report of the Ferguson courts came out and included information in addition to what you've indicated. And I know you had emails read yesterday concerning the directives to use the courts to generate revenue. It included emails with racist statements from clerks and police officers regarding litigants. And it indicated, it included information that the judges and the clerks imposed unwritten rules that they literally made up as they went through the court process. David indicated that the tickets might have no court date. It might have no speeding, the amount of the charge of speeding didn't include the speed the driver was going. All kinds of deficiencies that persons could not find out when they were going to court and when they needed to be to court. One report was that they found out the court was supposed to be held at night. They showed up at night. There was no court. And so one man made the janitor, he wrote out information and made the janitor promise to give it to the clerks the next day so that they would know he actually appeared, because he feared a warrant would be issued for failure to appear. So the first response of the Supreme Court was that we had to own the problem, that we had to accept ourselves and make perfectly clear that municipal divisions are state courts. They're a division of the circuit court. And then we had to communicate a clear message to Missouri judges, to attorneys, to court personnel, but also to the legislature and to the public, that this conduct is not acceptable in Missouri courts, that we will do all that we can to ensure that it does not continue. And we also communicated that we have been and should be proud of Missouri courts, that day in and day out in thousands of courtrooms or hundreds of courtrooms around the state, justice is done appropriately by persons who care, that are the role models for the right way to be a lawyer, to be a judge, and whose actions foster respect for our courts. But that isn't enough, that despite being proud of what we normally do, we had to make sure that that culture existed in every court in the state. And it hasn't been emphasized that in the one county, there are 81 municipal courts. And some of the municipal courts are tiny, that a person can drive a 2-mile strip of highway and pass through 8 municipalities. And so that is part of the problem. And so we had the attitude that whether the change needed was great or small, we had to be creative and we had to meet the challenge. And that we accepted that every individual in every case in our system of justice must be treated with respect and have his or her case adjudicated fairly and impartially according to the law. And until that is true in 100% of our courts, we cannot rest. That even the perception that justice is denied anywhere should concern us all, no matter who we are or where we are. And the intention was not to have an edict on high, but to inspire all persons in the court system to recognize you don't have to have a leadership title to be a leader. That each and every person, if they care to do so, can positively influence the conduct of others. And so through setting standards and being role models, each of us can establish a culture in the courts that values the judicial system, the law, and the litigants. And so we went to work. We amended the Supreme Court rule to mandate that municipal judges consider indigent defendants' ability to pay fine and costs when enforcing judgment. We took the bold move in Ferguson of creating a new municipal division and transferring all of the Ferguson cases out of the existing municipal court into this newly created division. And we worked with the presiding judge of the circuit to assign an appellate judge who was a former municipal judge and chair of our municipal education committee to hear those cases. Upon hearing that, the Ferguson judge resigned, and the appellate judge heard the dockets until a new judge was hired. Others stepped up. A voluntary group of municipal judges and others from around St. Louis became agents of change. They identified best standards. They developed a uniform fines schedule with maximum fines to eliminate exorbitant fines that had been imposed. They voluntarily recalled over 10,000 warrants because if anyone failed to appear, that was a new offense. And so they had an additional charge and new fines and costs. And so even the legislature passed laws to eliminate an offense of failure to appear. We sought information from teams of experts, from OSCA, from the National Center. They came to Ferguson. We received an SJI grant, and they studied municipal courts throughout the state. and to recommend best practices. And we appointed a blue ribbon committee that included 2 former Chief Justices of the Supreme Court and a former Chief Judge of the Missouri Court of Appeals, which was Booker Shaw. And they were charged with taking all of the information that was through the court's requested studies. It was from the Ferguson Commission, from the Arch City Defenders, a Better Together organization, and we solicited comments from the public, and they were to take all of this information and bring to us the best and most important reforms and evaluate the reforms according to what the court had authority to do. We also appointed a commission on racial and ethnic fairness of over 500 attorneys, judges, and others that was charged with studying the judiciary as a whole, the practice of law, the criminal, civil, juvenile, and municipal systems, and make recommendations to ensure equal treatment and fairness in our courts and the practice of law. And I know Booker, as a member of both a co-chair of the working group and as a co-chair of the Race and Ethnic Fairness Municipal Subcommittee, is here to talk about those groups and their work.
Thank you, Judge. So let me begin by reading to you a quote from the Supreme Court that basically gave us the charge to do the study and make the concrete recommendations to the Supreme Court. Most citizens form their first and most lasting impressions of the integrity, fairness, and efficiency of the judicial branch of government by their encounter with the municipal court. If municipal courts are not seen as courts, that is, as institutions committed to justice first and foremost, then the people's willingness to trust the entire judicial system at every level is diminished, and the judiciary's primary claim to legitimacy, that is, it seeks justice and fairness with integrity, is weakened. So in May of 2015, we began our quest. Our original charge specifically was that we reviewed all matters relevant to practice in municipal courts and to make recommendations to the Supreme Court concerning rules and changes that could be implemented by the court, by legislation, or otherwise. This is pretty broad. Shortly thereafter, the Supreme Court modified our charge and gave us 4 specific tasks. One related to the propriety of judges serving in different capacities in multiple municipal courts. Number 2, the authority of the Supreme Court to order court consolidation. Number 3, an examination of warrants, bonds, and incarceration. And 4, an examination and recommendations regarding the enforceability of judgments. The Supreme Court very wisely created a group that was diverse on many levels. There were 9 members of the commission, or of the work group. As the Chief has pointed out, myself and 2 former Supreme Court justices were the chairs of the commission, and the remainder of the work group were judges, lawyers from all over the state, diverse by way of geography, background. We had municipal court judge, a state court judge. We had the mayor of Kansas City. We had the president of the Missouri Bar Association. We had a law professor. It was a pretty diverse group. I was terrified because I thought, while I knew a lot of the players, I thought, I don't know, given our experiences in St. Louis County, which St. Louis County was very different from what was going on in other parts of the state, could we reach a consensus? Could we make meaningful recommendations together to the court? And we began, of course, by this time, we had a huge amount of resource data. As the Chief has pointed out, we had the National Center for State Courts. We had the Office of the State Court Administrator. We had the Ferguson Commission report. We had the Justice Department report, and on and on. We had probably 15 to 20 reports had pretty much been completed by the summer of 2015. But also what we needed to do to complete the mission we had undertaken was to go and study these municipal courts around the state and have public hearings regarding what the citizens perceived as the problems around the state. I would tell you that our first meeting, we had meetings electronically and by phone, and there was some dissension. When we had our first meeting together in Springfield, where Judge Lynch is, it was really a wonderful meeting where we got together. We studied the municipal courts in Springfield, and Springfield, Missouri, which is in the southeastern part of the state, has a wonderful municipal court system, and Judge Todd Thornhill down there was a gracious host, and really they had a model system down there. But for us on the commission, we had an opportunity to break bread and discuss our various ideas, and everybody was very seriously committed to working out resolutions to this problem, and committed to the idea that out of this Ferguson tragedy, and even though there were these differences in St. Louis County, we were committed to the strength and fairness of the judiciary in Missouri, and we recognize fully that if people are not perceived as receiving fairness in the municipal courts, it affects all of the courts in the state. We had our public hearing in Springfield, and maybe 2 people showed up because people were satisfied and happy with their municipal courts in Springfield. We then we had our public hearing in Kansas City, Missouri. And Kansas City, which, as you may know, is on the extreme western end of the state, they have a separate municipal court system that was established statutorily that operates differently from municipal courts in Springfield and St. Louis, and it is very professionally run. They have, from the beginning of their existence, have a public defender system that's in place at the municipal courts. It's been budgeted for. They have court administrator. It is run very much like the state circuit court. We had our public hearing there, and maybe 8 people showed up. So then we had our public hearing in St. Louis. And we were concerned about St. Louis. Really behind the scenes, we were concerned that people were so fired up in St. Louis, and it was going to be so contentious, we really didn't know what to expect. But we thought, we really should hear from the people, and in as much of an open way as we can, hear everything that people had to say. We had our public hearings in St. Louis in the Missouri Court of Appeals, which is in the Eastern District of Missouri in St. Louis. It's a beautiful historic building and courtroom. It was filled to overflowing with people who showed up with banners and posters and signs, and we went on for hours. Over 100 people showed up, and from organizations, from Washington University, from Better Together, from all of the various organizations, and just individual citizens who showed up and gave testimony about the experiences that they had, and which David has touched upon in the municipal courts. And I think that was just the most compelling work that we did. We were all so moved by that then we began our work to really put together something that made changes in the municipal courts. Ultimately, we recognized, though, that because of the tragedy that happened in Ferguson, the extremely unusual makeup of municipal courts in St. Louis County, that judges throughout the state, there was going to be a certain amount of disagreement about how we address these issues that would not negatively impact other parts of the state while we're trying to address the issues in St. Louis County. But it was clear to us that many of these, I don't know if we call them rogue courts or whatever, I mean, some of them were just a few blocks large, and it was clear to us that many of these municipalities and their courts had lost sight of their public safety function, and that they had largely become fine collection bureaus, and their primary purpose was just to collect revenue for the city. And I think as a whole, we on the commission felt that if we had a magic wand, we would have done something differently than what we recommended, because we were certainly in favor of some drastic changes in St. Louis County. But of course, we are constrained by law and the Constitution of the state of Missouri. So the two major areas we ultimately reached resolution on. Number one, I think the most highly contentious issue was court consolidation. People were so dissatisfied with the courts in St. Louis County that they wanted them basically shut down. For some of them, that perhaps as large as 50% of them were not functioning truly as courts out there. But we did not believe that the constitutional authority given to the Missouri Supreme Court allowed it to make that decision solely on the basis that some of these courts were not functioning properly, without anything more eliminating courts. But we did believe that by establishing court standards relating to due process, relating to facilities, relating to a number of areas, that the court could make a determination as to what courts out there were able to meet those minimum standards, and by determining that certain courts could not meet those minimum standards, that they could no longer function as courts.
And did the commission's work result in a report back to the Supreme Court?
We prepared about 140-page report, which dealt with all of these areas and many others. I think the second highly contentious issue, but one that I think in the city of St. Louis at least created so much concern by the citizens, and that was the appearance of impropriety. And that is where municipal court judges in one municipality were acting as prosecutors in another municipality, then acting as defense attorneys in another municipality, or municipal court prosecutors being prosecutors in several municipalities, which was fine, but then also acting as defense attorneys in other municipalities. And people, as the chief said, I mean, some of these municipalities were only blocks long. So an individual with, let's say, a broken tail light or a noisy muffler, they may end up with 4 citations having driven a mile in different municipalities, and some of them very exorbitant fines. And so they would end up showing up in these municipalities and saying, wait a minute, here, this guy was a prosecutor over there, now he's a judge over here, now he's a defense attorney over here. So we made recommendations to the Supreme Court that municipal court judges and prosecutors be held to the same ethical standards as state judges and prosecutors. That is, if you are a municipal court judge within a county, you cannot act in any other capacity, that is, as a prosecutor or as a defense attorney in that county. And the same with regard to prosecutors. If you were a prosecutor, you could only be a prosecutor in that county and not engaged in any other capacity.
You've taken on Yeoman's work for the judiciary with the work group, but then also, can you tell us briefly the status of the Racial and Ethnic Fairness Commission?
Okay, very quickly then, you know, the Supreme Court thereafter, and having received all of this information and under the leadership of Chief Breckenridge, decided there is lots of work to be done. We need to get ahead of this rather than, as we found out in Ferguson, this tragedy, of course, is going to bring about, I believe, some great results and some great work is being done, but let's get ahead of this. And so the Commission on Racial and Ethnic Fairness, there's 6 subcommittees. I am on the Municipal Court Subcommittee. And so we have been engaged in identifying barriers to access and fairness, examining biases or disparities in the various practice areas, and recommending measures to the Supreme Court. So we have made an interim report to the Supreme Court, and I won't go into the details about that right now, but primarily we've made 10 recommendations in 3 key areas, and those 3 key areas are with regard to experts, data collection, to collect data so that we know exactly what the problems are, Number two, with regard to court structure and governance, and this will, of course, provide those minimum standards to the Supreme Court for determining which courts are actually capable of functioning as courts, and then civil rights standards, and those having to do with protocols for provisions of notice of rights, for ability to pay, for legal counsel, and for impositions of fine, warrants, and bail.
Patty, when the Supreme Court gets the report from the work group, the interim report from the Commission on Racial and Ethnic Fairness, has the Supreme Court taken any further actions?
The court has. The first thing is the report received from the Supreme Court working group that took the actions that the community wanted and evaluated them as to what authority the court had. It was not warmly received. In fact, the chairs of the Ferguson Commission signed a letter saying that if the court did what its working group recommended rather than what the Ferguson court recommended, the court was returning Missouri to the days of Dred Scott, which was the infamous case where the Supreme Court of Missouri in the U.S. ruled contrary to the law against an individual and denied his freedom, and is thought to be one of the impetuses for the Civil War. So that tells you how strongly their recommendations were not embraced. The court took action that I have not seen in my 9 years, which I think is indicative of how important the court thought it was, the issue and the necessary actions, and met for days to look at all the recommendations. And we determined there need to be a two-pronged approach. There need to be structural changes as to rules and policies, to impose mandatory operating standards, and to attain uniformity. But we also recognize that many of the problems weren't caused by a lack of direction in the law. As to practices and procedures, it was a matter of personnel. And there were two ways to address that. One was education for those people who would intend to do the right thing, but did not lack, or they lacked the information, they lacked the knowledge as to how to do that. And then the other is that you have strong rules and you enforce those rules for those people who may have known what the law was, but choose not to follow it. We established a permanent committee on practice and procedures in municipal division. Nothing had existed that no group was charged with overseeing municipal courts before that time. And we gave them the directions that its highest priorities were to develop these operating standards for all the municipal divisions, and they had to be the same standards as for the circuit court. We obtained funding and have designated 2 full-time employees to be monitors for the St. Louis area municipal courts so that they can make sure that the criteria, the mandatory criteria, are being in effect, and that they can report to the court as to those courts that are not complying. We found that we wanted an indigency standard that was could be utilized in municipal courts, so that it had to be information that folks had when they came to court. It had to be simple. It had to be applied. And we found that just having that standard wasn't enough. We were told that a court in one county, north of St. Louis, they had the standard and the forms were available, and only one litigant in the 2 months they'd had the standard had ever picked up the form, filled it out, and utilized it. So there has to be protocols as to the judge directing determination, a need to determine indigency rather than rely on the litigants to bring it forward. And we develop protocols for all, we want them and have directed them to develop protocols for the presiding judges in all the circuits to have the role of monitoring. We even have given them the NACM Code of Conduct for court staff and asked them to review it and to recommend to the court its adoption or any changes to it. We found that the changes that we needed to, or the knowledge we gained from looking at the municipal systems, alerted us to the needs to make changes in the circuit courts. We have adopted a jury instruction that guides jurors to consider things like cross-racial identification in determining the credibility of eyewitness testimony. We have moved forward in our recognition that there needs to be a change to the cash bail system where people are held in jail because of a lack of ability to post a cash bail, and are moving forward to pilot a validated tool that assesses the risk of committing additional crimes or failure to appear. And so we're moving forward, and we're piloting that in St. Louis County as well as in 5 other circuits. We've also recognized that although we think we've worked diligently and we are making vast changes to the system, we haven't done a very good job communicating that we have not utilized an outreach. We just thought if we thoughtfully and thoroughly went through and made changes, that the community would know that and would see those changes, and that they would understand that we were making a difference. And we found in recent meetings that our lack of outreach and our lack of publicity has caused the community to believe, as we're coming up on the 2nd anniversary of Michael Brown's shooting, that we're just stalling, and that we're just having study after study and appointment of committee after committee, and that we don't intend to do anything and don't intend to make a difference, and that there is a real sense of urgency in making a difference. And so in our directions to the committees, we've said we have to have real action. We have to show there's a difference. And so the committee that met last week established deadlines for all of these concrete actions to come back to the court. And we're giving them deadlines of a month or 2 months to come back with some really concrete action items.
David, to those of us that have many years of experience in the judiciary, it seems like there's been a mammoth amount of work done on this issue. Okay. But as Patty mentioned, we're coming up on the 2nd anniversary of the Michael Brown shooting. How does the community perceive the court's response to the issues that were raised?
Honestly, I think they often think that there hasn't been sufficient response. And I think what you've spoken to, Chief Justice Breckenridge, is that breakdown in transparency and in communication is really felt by people in St. Louis and across the country. And just on parts before that we were speaking about before on this panel, about the urgency that there is for people experiencing these courts and going through these, they really don't feel like there has been an impact on their life. And that really speaks. I'm excited to hear that there's going to be new administrators to really focus on overseeing these courts, because if we're not really measuring and if we're not really talking about race, as we spoke to the report that came out, there was a lot of points of misalignment along with the commission report. And if you search that report for the words race or the words black or African American, it shows up maybe twice in that report. And once was a reference from a committee member that we talk too much about race in these issues. But if we're really not willing to speak openly, transparently, to really talk about what is the reality for people as they're experiencing these courts, then it's not going to seem like a change. And there's really opportunities, and I'm saying this to you all, that there's opportunities for people at all levels, not just from the top, but really for a bottom-up approach to having these changes, that it's not even just in these municipalities in North County that we see as corrupt, but it's really endemic, it's systemic, it's across all of our courts, that these instances of racial bias aren't just limited to a mostly black court in North County, but still exists in mostly white areas where black individuals will be met with that same amount of bias. So I really wanted to make sure that I put out a call to action that we in our spaces and our positions at all levels of leadership have the opportunity to really center these issues, to talk about them, to speak about them openly. We're at a point in our lives, in our history as a country, where we're coming up on a new civil rights movement. In the events of this past week, with the 2 additional deaths of 2 black men in the events in Dallas where the police officers were killed, and I also personally had an incident with police in this past week. And I was talking on the phone to my dad, and I was like, he grew up, was kind of a teen and into his 20s in the civil rights movement of the 60s. And I was like, did it feel like this back then? And he was like, yes, it almost feels no different. And so I just want to stress this moment that we're in and this opportunity that we have to really do this the right way, to think about these issues in a new way, to really center these issues and forge new conversations, new connections between people and these systems that we have to ensure justice. So that when we have courts and the judiciary that are meant to ensure that people are treated fairly, that we have justice, that there's actually systems for accountability for people of color. And until there's clear articulations of that, and there's a lot of animosity that comes from that those historical experiences, but until we really start to build bridges that way, and we really start to talk about these issues openly and transparency, and center racial equity, center new processes that really take in community involvement, that provide these alternatives for how people interact with courts, there won't be satisfaction from people, and there will continue to be protests. And so I just wanted to make sure that I put that out there.
Thank you. The public studies and reports and the conversations that have occurred, the conversations that will occur, don't necessarily reflect everything that has been done, because some actions just take a lot of behind the scenes work. I chair the Missouri Court Automation Committee, and that is charged with developing and implementing a statewide court automation system. And we have spent the last 20 years deploying a statewide case management system, and just recently completed statewide e-filing. Except to a large degree, the municipal courts were left out of that process. And so we realized that as soon as we started seeing municipal court issues come up 2 years ago, we started working, how can we use automation to provide that accountability and that transparency of how cases are handled? Why can't municipal court cases be on our statewide CaseNet system, where anybody can look up any case and see what happened on that case and see that docket sheet? And so we've been working like crazy to find solutions to that. We have some inherent barriers. Our statewide case management system is built on 1980s technology that we deployed in the 1990s, and it is difficult. It is not user-friendly. There is a very high learning curve. And so the Office of State Court Administrators, in conjunction with the Missouri Court Automation Committee, has made it our #1 priority to develop a second-generation case management system with our initial emphasis on the municipal divisions. To give you some idea of the scope of that, however, we have 115 court installations of our case management system in the state courts. There are 475 municipal divisions that have their own courts. Okay. Of those 475, we have 65 of them on our current case management system. So that leaves 400 municipal divisions to bring into the system, and looking for resources to do that. We simply don't have the resources to train them on the current case management system. So we have developed our second generation of case management with a bullet focus on municipal divisions, making it user-friendly, easy to learn. And we are going to start with those municipal divisions that are not automated and then bring them on. We are on schedule to pilot that the first quarter of 2017 and to start rolling it out next year. With that, we want to spend the rest of our time answering questions because this is a hot topic. Patty, you've got the microphone there. And if you'll wait for Patty to get the microphone to you, maybe does someone else have a microphone? Or okay. If you have any questions, we would be glad to take questions.
Thank you. Hi, my name is Amy Quinlan. I'm the Deputy State Court Administrator.
Can you hear? We can't hear.
My name is Amy Quinlan, and I'm the Deputy State Court Administrator for the state of Delaware. And we are in the process of trying to look at racial equity in our criminal justice system. The Chief Justice convened a commission to look at this, and we've been doing some of our own public hearings. One of the issues that's come up, and I imagine this is an issue not just on racial issues, but on politics, it strikes me that we are having a hard time having a conversation at all about opposing points of view, and that we've in some ways forgotten how to do that, and that the courts, attorneys, courts, judges, we're the very place that these conversations are supposed to happen. And we've had a lot of discussion in Delaware about how to have these conversations because we want them to be real, we want them to be authentic, but in some ways we don't even have similar vocabulary. We don't even know how to approach it. We're afraid to raise these issues, and it's created a big disconnect. And so we're not even starting at the real issues. We're starting about learning how to even have those conversations. I suspect you encountered this, you spoke to this a little bit ago. I'm wondering if you have any thoughts, points of view, because it's so important to get to the conversation. How do you even start to have it when so many of these issues touch at the very hearts and souls of folks in so many different ways?
I think the court system has not been nearly as effective. We're starting it, and the Race Commission is expecting to do focus groups and community conversations. And I know you heard the program, but I think the Ferguson Commission was the model for all. You engaged 3,000 individuals in St. Louis County.
Yeah, so I think the first thing sometimes is just to acknowledge that it's difficult, right? To know that these are issues that our country has dealt with for 400 years, and so we're here in the present dealing with those 400 years of history. And so I think something that you really spoke to is that shared language aspect. Sometimes it can feel like we're just talking past each other, and sometimes it's just understanding that that's a process. Like, make sure that you have those initial principles and values about how people are going to come into the space. For Forward Through Ferguson now, we kind of have these values of what we call radical collaboration and radical listening, which just kind of dictates the way that you enter in spaces, who we think of as experts, the different ways that we're trying to flip on its head how we think about power structures and how we talk about race. So I think remembering that it's a process. The commission didn't start off being able to have these conversations super productively. Those initial meetings were incredibly intense. I'm talking about people yelling, protesters, and all of these things that kind of converge, but it's having that space and really intentionally having that space that can be very powerful in making people feel like their voices are heard. And sometimes it'll take until after people feel like their voices are heard before you can have a conversation that starts to move things forward. And so there's some, I think that's a similar issue that a lot of people around the country and people in St. Louis are really working through, and something that Forward the Ferguson is also thinking about. And how can we create toolkits around racial equity, around having these conversations, around what does it look like to disaggregate your data, and really have measurable outcomes that you can move toward. And so that's something that we're really thinking about now. How can we build shared language, create these toolboxes for how communities can have these conversations and move forward?
And David, did you rely on community leaders, but also expert facilitators to help guide those discussions?
Having facilitators that are experienced is essential. It was incredibly essential. And we had that, we worked with some organizations in St. Louis, as well as having people like Bethany Johnson-Giroir, the managing director, who has who's done a lot of work in mental health and having difficult conversations like this. It's really is essential to invest in having facilitated conversations, and really understanding that you will have to put resources towards these in order to really move these conversations forward.
Our time is up. We have just scratched the surface. The panel members will be down in front if you have further questions or want to talk further about it when we're finished. Scott?
I want to mention that under Chief Justice Breckenridge's leadership, this panel was as eager to be in front of us as we were to have them here. And I think that's a testament to your commitment to, most importantly, the communities we serve, but also to the profession we've chosen and to the judiciary at large. And David, I think the point you made a few moments ago is an important takeaway for me, and that is that urgency remains on this issue. We noted yesterday that the moral arc of the universe bends toward justice, but we have to do the bending. And I think that in your candor, in your commitment, and in your individual and collective leadership, you've given us some sense of what that bending looks like. Thanks again. We really appreciate your time this morning.